Hello and welcome. My name is Garrett Snedeker, and I'm the Deputy Director of the James Wilson Institute. JWI seeks to restore to an audience of lawyers, judges, scholars, law students, and ordinary citizens the first principles of our law and the moral ground of our rights. On behalf of AEI and JWI, we're pleased to have you join us for our afternoon webinar, Natural Law and Originalism, in concert or at odds. Before I provide an overview of our program and introduce our moderator, I wish to thank AEI for its co-sponsorship of this webinar, in particular our friend Yuval Levin for hosting this program under AEI's Center for Constitutional, Social, and Cultural Studies, and also Elaine Allen, who has managed logistics behind the scenes. Today's program has been in the works for a little while, though events in the intervening months have only added to its timeliness. We originally sought to craft a program in March that would lay out some basic concerns among conservative lawyers and thinkers about the compatibility of originalism with natural law. Peter Wallison was generous in taking a keen interest in Hadley Arkes' life's work on the subject from the outset. However, originalism has since faced two novel challenges that underscore the timeliness of our webinar. First, in April, Professor Adrian Vermeule of Harvard Law School published a popular critique of originalism from the political right in The Atlantic. Vermeule questioned whether the originalism presently on offer in our jurisprudence does enough to secure what he calls the common good. Second, in June, Justice Neil Gorsuch's majority opinion in Bostock versus Clayton County employed textualism, a close cousin of originalism, to construe the meaning of sex in the Civil Rights Act of 1964 to apply to transgender litigants. And so now, with another self-professed originalist judge, Amy Coney Barrett, set to join the Supreme Court, seeking to understand how originalism aligns, if at all, with the natural law in our jurisprudence is as important as ever. The format of our program will be as follows. Our moderator, Professor Joel Alicea, will introduce our two speakers who will lay out their arguments over the course of the next 50 minutes. Then there will be open discussion among the panelists, followed by interactive Q&A with you, the audience, until about 3:30 p.m. Eastern. Throughout the webinar, we encourage you to email questions you would like Joel to ask. You can either ask those questions named or anonymously during the Q&A to elaine.allen@aei.org. Or if you prefer, you may convey your questions on Twitter in under 280 characters using the hashtag AEIOriginalism. If you're following the program on AEI's link, Elaine's email and the hashtag are spelled out for you. Finally, I'm grateful to introduce our moderator, a friend I've known for several years, Professor Joel Alicea. It's great to refer to him as professor now because he's joined the faculty of the Catholic University of America Law School this fall after having practiced law for several years at the firm of Cooper & Kirk. He previously served as a law clerk for Justice Samuel Alito on the United States Supreme Court and for Judge Dermot O'Scanlan on the United States Court of Appeals for the Ninth Circuit. Professor Alicea's scholarship has focused on constitutional theory. He has been published in such places as the University of Pennsylvania Journal of Constitutional Law and the Harvard Journal of Law and Public Policy. He's also been active in public debates about constitutional law, publishing essays in journals such as National Affairs and Public Discourse. Professor Alicea graduated cum laude from Harvard Law School and summa cum laude in Phi Beta Kappa from Princeton University. Professor Alicea, the floor is yours.
Thank you, Garrett, and thanks again to AEI and the James Wilson Institute for sponsoring this event. It's my pleasure to introduce our two interlocutors today. So I'll start with Peter Wallison. Peter Wallison holds the Arthur F. Burns Chair in Financial Policy Studies and is co-director of AEI's program on financial policy studies. Prior to joining AEI, he practiced banking, corporate, and financial law at Gibson, Dunn & Crutcher in Washington, D.C. and New York. Mr. Wallison has held a number of government positions. From June 1981 to January 1985, he was general counsel of the United States Treasury Department, where he had a significant role in the development of the Reagan administration's proposals for deregulation in the financial services industry. And from 1986 through 1987, Mr. Wallison was White House counsel to President Ronald Reagan. Mr. Wallison is the author of numerous books, including Ronald Reagan, The Power of Conviction and the Success of His Presidency, and his most recent book, Judicial Fortitude, The Last Chance to Rein in the Administrative State. He received his undergraduate degree from Harvard College and his law degree from Harvard Law School. Hadley Arkes has been a member of the Amherst College faculty since 1966, and since 1987, he has been the Edward Ney Professor of Jurisprudence. He assumed emeritus status in 2016. He is the author of 5 books with Princeton University Press and 2 with Cambridge University Press, including First Things, from which the journal First Things took its name, and his most recent book with Cambridge, Constitutional Illusions and Anchoring Truths. Professor Arkes is the founder at Amherst of the Committee for the American Founding, a group of alumni and students seeking to preserve at Amherst the doctrines of natural rights taught by the American founders and Lincoln. That interest has been carried over now to the founding of a new Center for the Jurisprudence of Natural Law, the James Wilson Institute on Natural Rights in the American Founding, one of the sponsors of this event. Professor Arkes received his undergraduate degree at the University of Illinois and his doctorate from the University of Chicago. As Garrett noted, we will first hear from Mr. Wallison and then from Professor Arkes. I will then offer a few comments and pose a few questions to our 2 interlocutors before we open it up for Q&A from the audience. And I will then field those questions from you all and pose them to our 2 participants. But we'll start first with Mr. Wallison, so over to you.
Thank you very much, Joel. It's a pleasure to be here. I just want to point out to everyone, I'm in Colorado, and this is business attire in Colorado. Don't have ties out here. But nevertheless, I hope to be taken as seriously as those who are properly dressed are taken. To a conservative, the idea that there are natural laws and natural rights beyond what is outlined in the Constitution is an attractive concept. The theory holds that there are moral underpinnings to our legal system that in effect enhance and assure the proper implementation of the rights enumerated in the Constitution. For example, as Professor Hadley Arkes, the chief exponent of this view, writes in his 2010 book, Constitutional Illusions and Anchoring Truths, there is a serious concern, I'm quoting here, there is a serious concern held by some of the most thoughtful among the framers that the Bill of Rights would have the effect of narrowing or truncating the rights protected under the Constitution. And it would have that effect mainly because it would misinstruct the American people about the ground of their rights. According to Professor Arkes, we must, so to speak, go beyond the Constitution to recognize and implement the underlying moral principles that are implicit in the Bill of Rights. As an example of an underlying moral principle not specifically included in the Constitution, Professor Arkes points to Chief Justice Marshall's decision in the 1810 case, Fletcher versus Peck. In this case, which arose in Georgia, various landowners were being sued for the return of land they had purchased from a seller who, unknown to the buyers, had obtained the land by fraudulent means. The Constitution contains no provision directly on this point, but Marshall, citing the Constitution's prohibition on states impairing the obligation of contracts, held that this restriction was based on the moral principle that once a transaction has been completed, a purchaser who bought property without notice of the seller's impaired title should not be deprived of rights he had bargained for. As attractive as it seems, the idea that various moral principles underlying the Constitution's words can be invoked by the courts to decide cases. And it poses a challenge to an originalist interpretation of the Constitution that is now popular among conservatives. Let me define that a bit. The most prolific originalist, as everyone knows probably, was Antonin Scalia, who in 2003 defined originalism this way: the theory of originalism treats a constitution like a statute, giving the Constitution the meaning that its words were understood to bear at the time they were promulgated. Originalism, I think, is fair to say, I quoted, that was a quote from Justice Antonin Scalia. Now going on, originalism, I think it's fair to say, is now the dominant system for constitutional interpretation among conservatives. It's attractive to conservatives, I believe, because it challenges the generally liberal view that the US Constitution is a living document and should be updated by the courts to conform to the changing mores of the American people. Limiting the interpretation of the Constitution's words to their meaning at the time the Constitution was written is one way, perhaps the most effective way, to combat the idea that the Constitution is a living document and malleable in the hands of the courts. Supporters of the living Constitution hold that various ideas expressed there, the right to bear arms, the death penalty, the meaning of cruel and unusual punishment, must be updated to the sensibilities of the American people today. If this is to be done, say originalists, it should be done through congressional legislation or amendment of the Constitution itself, not through judicial interpretation. Proponents of originalism point to the unending controversy over abortion as an example of what happens when judges step into deciding these fundamental issues themselves. The stakes are high. Liberal legal scholars have ideas for changing the Constitution in significant ways without actually amending it. For example, Harvard law professor Adrian Vermeule, who for unknown reasons has been called a conservative, has recently published an article in Atlantic magazine with the title Beyond Originalism, in which he argued for what he called common good constitutionalism. In the article he wrote, and I'll quote here, "The central aim of the constitutional order is to promote good rule, not to protect liberty as an end in itself. Constraints on power are good only derivatively, insofar as they contribute to the common good. The emphasis should not be on liberty as an abstract object of quasi-religious devotion, but on particular human liberties whose protection is a duty of justice or prudence on the part of the ruler." Close quote. Conservative, this formulation is simply a prescription for subordinating traditional American liberties to some vague idea called the common good. That, I believe, is also the nub of the issue between originalists and Professor Arkes's views. The proponents of originalism believe that holding to the original public meaning of the Constitution's language is the most effective way to preserve the liberties of the American people. Government can have many objectives, some as vague as the common good, but the American Constitution was conceived as a charter of liberty. The Federalist Papers just cannot be read any other way. Those who support originalism are attempting to preserve the liberties of individual Americans and believe that turning the Constitution into a living document focused on someone's idea, for example, of common good, will ultimately mean the triumph of autocracy and the end of liberty. Professor Vermeule writes, and I'm quoting here again, "Common good constitutionalism will favor a powerful presidency ruling over a powerful bureaucracy, the latter acting through principles of administrative laws, immorality, with a view to promoting solidarity and subsidiarity." To me, this sounds more like Big Brother in George Orwell's 1984 than common good constitutionalism, but there it is, a prescription, in my view, for autocracy. Thus, although Professor Arkes is certainly not an advocate of a living constitution, his view that there are unstated moral principles underlying the Constitution and usable in constitutional interpretation could provide a foundation for new societal claims for rights, privileges, and restraints, the very outcome that many originalists seek to avoid. Indeed, with the advent of the woke phenomenon, the attempted cancellation of people who hold divergent views, it is not hard to imagine that empty phrases and objectives such as common good might be the direction taken by the advocates of the living Constitution in the future. There is no reason to suppose that the natural law and natural rights philosophy outlined by Professor Arkes is a precursor to this nightmarish prospect. In his 1990 book, Beyond the Constitution, he writes, "We cannot apply," and I'm quoting here again, "we cannot apply the Constitution in the practical cases that arise every day unless we move, so to speak, beyond the Constitution. We will persistently find a need to appeal to those moral understandings lying behind the text, the understandings that were never written down in the Constitution, but which must be grasped again if we are to preserve and perfect the character of a constitutional government," close quote. The question raised by this view, of course, is whether the ideas underlying natural law and natural rights would merely complement the Bill of Rights by finding the underlying moral principles on which these rights are based, as Chief Justice Marshall did, say, in Fletcher versus Peck, or would be the foundation for constitutional changes that would eventually limit the existing liberties of the American people, perhaps in the interest of, yes, common good, whatever that is supposed to mean. For example, we've all heard the collectivist jibe about liberty. "Every man for himself," said the elephant as he danced among the chickens. There is a moral principle in that idea that could provide the foundation for a restrictive common good society in the future. The answer to these questions rests in part with the specific views of the originalists, who may now include a majority of members of the Supreme Court. Recent Supreme Court cases suggest that originalists on the court are beginning to develop a coherent system of statutory interpretation. For example, in Sessions versus DiMaia, a case decided in 2018, Justice Neil Gorsuch, another avowed originalist, joined the 4 liberal justices in holding that the statutory language under which DiMaia was convicted was unconstitutionally vague. The void for vagueness doctrine, at least properly conceived, Gorsuch wrote, quoting here, "serves as a faithful expression of ancient due process and the separation of powers principles the framers recognized as vital to ordered liberty under our Constitution." Then Gorsuch continued, "In my view, the weight of historical evidence shows that the clause sought to ensure that people's rights are never any less secure against government invasion than they were at common law." Here, Justice Gorsuch is using language with which Professor Arkes would probably be comfortable, pointing to both extra constitutional origin of the doctrine and its connection to the common law with which the framers would have been familiar. Other originalists did not agree. Chief Justice Roberts, joined by Justices Kennedy and Alito, did not find the disputed language to be unconstitutionally vague in DiMaia. Justice Thomas, on the other hand, did not think that the void for vagueness doctrine was an element of due process at the time the Constitution was ratified, was not properly included, therefore, in the due process clause, and thus was not entitled to originalist approval. Thomas's position is interesting for what it says about an originalist analysis. According to Justice Thomas, and I'll quote, "The vagueness doctrine is legitimate only if it is a settled usage and mode of proceeding existing in the common and statutory law of England before the emigration of our ancestors. Until the end of the 19th century, there is little indication that anyone believed that courts had the power under the Due Process Clause to nullify statutes on vagueness grounds. That is not because Americans were unfamiliar with vague laws. Rather, early American courts, like their English predecessors, addressed vague laws through statutory construction instead of constitutional law. It is important to note that both Gorsuch and Thomas, although they disagreed on whether the void for vagueness doctrine was actually understood and used in England or the colonies before the ratification of the Constitution, they did agree that the use of the void for vagueness idea at the time of the Constitution's enactment was the touchstone of its legitimacy. This gives the originalist approach to statutory interpretation an historical foundation that places a limit on its use in constitutionalist jurisprudence. Unless there is a history of an idea's use at or before the time of the adoption of the Constitution, it would not be considered legitimate for use in an originalist interpretation of that Constitution. There is common sense in this. The people who were voting to ratify the new Constitution would not have done so if they believed that their historic privileges and immunities, in other words, their rights, were actually reduced by doing so. So it is a principle of originalism that the Constitution, even though it might not explicitly recognize these rights, even in the Bill of Rights, embodies the rights that were guaranteed under the common law of the mother country before the Constitution came into force. Professor Arkes would probably agree with this, but he adopts a different standard in his book. Beyond the Constitution is the name of the book, and in that book, he invokes unwritten moral understandings, not specifically rights under law that must be included in the interpretation of the Constitution. And here his case starts to diverge, I believe, from originalism. Even, quoting here from the book, even in the state of nature, he writes, men did not have a natural right to do mischief or inflict injuries. And on the other side, even in the state of nature, people had a right not to suffer these wrongs. It is not the existence of the government that created these rights, he writes. It was the existence of these rights that called forth and justified the existence of government. We can agree that protections against violence are inherent in the reasons for the establishment of government. But the question is whether Professor Arkes's moral principles or understandings lying behind the words of the Constitution and ready to be summoned by judges are so widely accepted that they are properly described as human or moral rights. If so, then Professor Arkes's approach can be seen as consistent with originalism. And originalists should have no objection to the recognition of these rights by courts because they would have been recognized as moral principles and rights both by the framers themselves and the American people who ratified the Constitution. However, this is not the end of the matter. Moral principles, it turns out, can be the foundation for new rights that have not been universally accepted. That's what the Supreme Court did, for example, in Obergefell versus Hodges, ruling that that same-sex marriage is a human right. Chief Justice Roberts and Justice Scalia and Thomas dissented, with Justice Scalia filing a separate dissent in which Justice Thomas joined that stated in part, quoting, "It is not of special importance to me what the law says about marriage. It is of overwhelming importance, however, who it is that rules me. Today's decree says that my ruler and the ruler of 320 million Americans coast to coast is a majority of the 9 lawyers on the Supreme Court. The opinion in these cases is the furthest extension in fact, and the furthest extension one can even imagine of the court's claimed power to create liberties that the Constitution and its amendments neglected to mention. If the court can create new rights on moral grounds, it can also create new restraints. especially if unwritten moral understandings can be invoked by judges in support of the existence of these rights or restraints. The objectives of originalism cannot be met if the courts continue to discover and enforce new rights or new restraints based on such empty ideas as common good, or other unstated moral values that were not widely accepted at the time the Constitution was ratified, and perhaps even today. With all respect, this is a known unknown. For this reason, I reluctantly conclude that Professor Arkes's attractive concept of natural law and natural rights is too unbounded and open to authoritarian ideas like Professor Vermeule's common good, and thus inconsistent with originalism as understood by conservatives. Thank you.
Thank you, Mr. Wallison. Professor Arkes?
Okay, first to Peter, I wasn't sure what the dress is, so I use Oscar Wilde's old line. I compensate for being overdressed by being overeducated. But I want to thank first Peter and my friends at AEI for inviting me in, especially to Peter, who was giving me the compliment of dealing with my work and dealing with things that have not been entirely familiar to him. Okay, I'm quite grateful for that. With his forgiveness, I would tell a story we both know about that. An award dinner where a while back, one of the awardees said, I asked my wife, darling, in your wildest dreams, did you ever imagine I could get an award of this kind? And he said, she said, darling, I don't know how to convey this to you, but you're not in my wildest dreams. And I may not be in yours, but I'm grateful for the honor it has given me the honor doing here. But as my friends know, I've argued for many years that the comedians are really in the same business as the philosophers, because they make their livings off the shades of logic in the language and inspired mistakes. You think of Mr. Richard Larry and his the entertainment he offered to the world. The history of the world is seen in the papers of his undergraduates, a compilation containing items of this kind. That Socrates was a Greek teacher who died from an overdose of wedlock. That Louis Pasteur discovered rabbis, a cure for rabbis. But long before that, Sir Francis Drake circumcised the world with a 100-foot clipper. Now, at times, the joke reveals ideas that people have taken as the anchoring commitment of their lives. So you think of Bertrand Russell's line about Mrs. Christine Franklin Ladd, who was a solipsist, who professed that she didn't know whether there was anyone in the world apart from herself. But she's also so disappointed that she couldn't find other solipsists to come to meetings of solipsists. Now, I used to say that if our ears were properly trained, we would probably induce the same urbane giggling when we heard this proposition, which has become one of the most widely traveled fallacies in our public discourse. If there were indeed moral truths that hold their truth in all places, they would be widely respected in all places and recognized, as Peter said. And the very fact that these moral questions inspire disagreement is prima facie evidence that those truths do not exist. Well, of course, the philosophers would call this a self-refuting proposition because it lends itself to this. The very presence of disagreement indicates the absence of truth. I record my disagreement with that proposition and its own terms. That establishes its falsity. Yet Harry Blackman was willing to found a whole new branch of our jurisprudence precisely on a proposition of that kind, which collapses, self-destructs in 6 seconds. And in Harry Blackman's line, it went this way. When so many learned people in law and religion, philosophy, cannot agree on the question of human life begins, obviously, there is no answer that judges are in a position to articulate. It's a proposition that, as I say, self-destructs in 6 seconds. And it self-destructs because it just runs into the anchoring proposition of the laws of reason, the law of contradiction. Two contradictory propositions cannot be true. And what comes as news to many lawyers and writers is that the natural law finds its ground not in theories, but in those anchoring or necessary truths that can't be denied without falling into contradiction. My late beloved friend, I'm going to differ signs from my director here. Where do you want me to go? Okay. My late beloved friend, Daniel Robinson, said that he wanted as the epitaph on his tombstone. He died without a theory. Now, Dan Robinson had written 18 books for academic presses. He was a figure in the neurosciences. He spent his last 20 years lecturing at Oxford about Kant, Hume, and Thomas Reid. He was no stranger to theories. But when he said that, it was part of his appeal to that common sense philosophy of Thomas Reid, the great Scott philosopher who's known to the American founders. He appealed to those axioms of common sense that any ordinary and functional person not only knew, but had to take for granted in getting on with the business of life. And so the average man, before he could start bantering with David Hume about the meaning of causation, the average man understood his own active powers to cause his own acts to happen. Okay. Now, some of us have followed Reid and found the ground of the natural law, as Robinson said, in those maxims of common sense that ordinary man is compelled to take for granted in getting on with that business of life. No theories. Aquinas said that the divine law we know through revelation, but the natural law we know through that reasoning that is accessible to human beings as human beings. And that was behind Jefferson's line in that famous letter to Peter Carr when he said, you could give the same moral question to a plowman and a professor, and the plowman was as apt to get it right because he would not be distracted by artificial rules, call them theories. This is where the American founders found the ground of the law in those axioms of understanding, that they could count on ordinary people to understand. And one of the signal marks of the genius of Hamilton, James Wilson, Marshall, is that they could trace their judgments back to those anchoring axioms, to those moral truths that were there before the Constitution, and the truths that would be there even if there were no Constitution. The litigation over Obamacare, my dear friend Greg Katz is arguing the first day, invoked that line from John Marshall, and actually Daniel Webster, in the old Dartmouth College case, to say that to impose upon people a contract they did not want, as in force them to buy medical insurance, could be as bad as impairing the obligation of a contract they had willingly made. Now, years later, Justice Story would say in his commentaries, that principle would be true even if there were no Constitution. In a similar way, John Quincy Adams then argued that that right to petition the government was simply implicit in the idea of a free society and a Republican government. And it would be there even if it hadn't been mentioned in the First Amendment. It would be there even if there were no First Amendment. It would be there even if there were no Constitution. My point here is that the American founders had access to an understanding of moral truths and principles of lawfulness that were there before they made the Constitution. They drew on those principles as they shaped the Constitution. They saw the need to keep drawing on them, applying the law to the cases coming before them. And the Constitution was not the source of their moral or legal understanding. The purpose of a Constitution was to arrange a structure of governance that was consistent with those underlying principles. You know, with the same underlying principles, we could have a confederation as well as an integrated national government acting upon individuals. So people ask, well, why do you need the Constitution? Well, we do need to know certain points of structure and operation. I do want to know whether a state can make its territory available as a military or naval base for another country. I do want to know who succeeds the president, whom the army will obey if a president dies in office. These are key matters of governing rules and structures. But what we've been given with originalism, I'm afraid, has been a rather truncated understanding of the original meaning of the Constitution, because that understanding has been detached precisely from the understanding of the founders of the principles that were there before the text, including those axioms of judgment that they thought too fundamental to need writing down. One of the most elegant examples is one that Peter cited, but I think he glided past the deeper point. That was John Marshall's opinion in the classic case of Fletcher versus Peck. As Peter told you, the case involved the question of the corruption in the granting of lands, the attempt of a legislature to undo the grant, but then facing the prospect of many innocent buyers of different parcels of land. Marshall saw the recalling of the grant and the undoing of the purchases as an impairment of the obligation of contract. And so he could have simply settled the whole case by invoking the Contracts Clause, Article 1, Section 10. But instead of doing that, he did something far more elegant. He showed how the Contracts Clause could be drawn deductively with the force of a syllogism from that deeper underlying principle on ex post facto laws, the principles that barred you from punishing people for things that were not illegal, punish them after the fact, enlarging the penalties. That principle was thought to be utterly central to anything calling itself the regime of law. You may recall that Oliver Ellsworth and James Wilson opposed putting it in the text of the Constitution because they thought it was so obvious that everyone knew it. Okay, but once Marshall established that ground, the principle of the ex post facto law, as the ground of his judgment, he was able to do something quite striking. He could say, Georgia is a great state. It is part of the American empire. But even if Georgia were a separate sovereign state outside the Constitution, outside the Union, outside Article 1, Section 10, this law would still be wrong because its wrongness is rooted in a proposition that does not depend at all for its validity on being mentioned anywhere in the text. Again, those remarkable lawyers and judges among the founders show that rare genius in tracing their judgments back to those anchoring axioms, as Marshall called them. You think of that interesting moment at the end of Gibbons versus Ogden, the classic Commerce Clause case. At the end of the case where Marshall apologizes to his readers for spending so much time demonstrating what should stand in the class of an axiom. That is, he assumed that all of his literate readers knew that before you can hold a demonstration, certain key axioms had to be in place, like the law of contradiction and controlled experiments. If I didn't understand the law of contradiction, there's no way it could have been explained to me in the form of the experiment. It's one of those things I have to understand before I step into the experiment. And that the founders were utterly clear on the properties of this proposition is nowhere indicated with more elegance and economy than in that opening paragraph that Alexander Hamilton had in the Federalist 31, a paper on taxation. And in the course of that paper, he didn't reach any conclusion different from what Bob Dole would have reached in her own time. But anyone looking at the text would have seen some strikingly different furnishings of mind. But this is how Hamilton put it. He said, in disquisitions of every kind, there are certain primary truths or first principles upon which all subsequent reasonings must depend. These contain an internal evidence, which antecedent to all reflection or combination, command the assent of the mind. Of this nature are those maxims of geometry: two lines cannot enclose a space, two things equal to a third must be equal to one another, and of like nature must be those maxims of ethics and politics: there cannot be an effect without a cause, that the means must be proportioned to the end, and there ought be no limitation placed on a power destined to effect a purpose which is itself incapable of limitation. Just the way Bob Dole would have done it, I think, if he just, bent his mind to it. When Hamilton referred to those things that could be grasped as first principles, grasped per se nota, as true in themselves, they could be grasped by ordinary folk. Or what kinds of things could ordinary people grasp in that way? Well, what about that proposition that Thomas Reid, James Wilson, even Kant regarded as the truly first principle of all moral and legal judgment? That it made no sense to cast moral judgments of praise or blame on people when they didn't have the active powers to cause their own acts to happen. And we say, what do we expect the ordinary man to say if we told him that Jones, being prosecuted for burglary, was in intensive care recovering from surgery at the time that the burglary was committed, or that he hadn't been born yet? Wouldn't we expect anyone to be wondering why that man is being prosecuted? The ordinary man to wonder why that's being done, which is to say the ordinary man would grasp as a matter of common sense that first principle, that we don't hold people blameworthy for acts they were powerless to effect. Now that principle underlies not only the insanity defense in our law, but it comes into play also with the principle on racial discrimination, with the assumption that people are determined or controlled in their conduct most critically by race, by forces outside their control. So that if we knew the race of anybody, we could make some interesting moral inferences about them. We've seen judges writing in this vein about people being punished, in effect, for their race, for conditions they were powerless to control. But that principle underlies so many other things, many other places where people may not be in control of their own acts. Of course, there may be the most difficult question of whether Jones was really under hypnosis or incapable of acting. All these are matters that may be quite contingent on circumstances and maddeningly variable. But what I point out is that the one thing in this mix that is never variable and never contingent is the principle itself. That if Jones really was powerless to effect his own act, he cannot be held blameworthy and responsible. That principle will never cease to be true under any circumstance. It'll be the one thing remaining stable and readily grasped, even though everything else may be in doubt. Well, how many of these propositions do we have? Well, more than people seem to realize, because that from that anchoring first principles, we can draw out by implication a skein of principles and rights that we may not even be aware of any longer. John Stuart Mill wrote that we stop using the language of like and dislike and begin using the language of right and wrong, as we think people may be rightly punished for what they're doing. But if we take seriously this matter of innocence and guilt, then we want to be careful before we visit punishment on people. And therefore, we're obliged to use the most demanding canons for the assessment of evidence, rather than pummeling a suspect or having him out run over hot coals. And if we go further down that line, we would draw out the implication, say, that anyone accused of crime should have access to the witnesses and evidence against him for the sake of rebutting them, and in rebutting them, getting a verdict that is substantively accurate in discriminating between innocence and guilt. That is, by the moral logic of this, a person would have a right, quote, to be informed of the nature and cause of an accusation, to be confronted with the witnesses against him. By the logic of this proposition, this right would be simply implicit in the rule of law, even if there were no Sixth Amendment, and even if there were no Constitution. Let me give you just one more example in that vein, drawn from the same logic as that anchoring first principle. And this one happens to offer a strand that runs more widely in our laws. And you can set it up in this way. What do you think the average man on the street would say if we put this question to him? From the fact that someone is tall or short, heavy or thin, darker or lighter, that he stutters, he's afflicted by deafness, can we make any inferences as to whether we are dealing with a good or bad man who deserves to be welcomed, or shunned, praised, or blamed? Okay. The common sense of the matter, grasped by most people, could be explained by philosophers in this way, that we simply can't impute to any of these features, height, weight, clarity of speaking, hearing, wealth, or poverty, we cannot impute to any of them a deterministic force in controlling or determining the moral character of anyone. To recognize this point is to recognize a truth death threats to many of our cases is in blocking indigents from coming into the state of California. And Robert Jackson said we can't make any inferences about the nature of people simply by knowing that they're poor. Okay? But the most dramatic example I could give you is probably the example of the baby Jane Doe case on Long Island in the 80s, which eventually made its way to the Supreme Court. And it remains vivid to me because I was in the courtroom the day that Chuck Cooper was arguing the case. The case involved an infant afflicted with spina bifida and Down syndrome. The parents and their doctors withheld medical treatment from this newborn, and the Reagan administration went into court. The administration wasn't insisting that the baby be given a heroic and futile operation if it couldn't save the baby's life. But what they wanted to find out is whether it really rested on a medical judgment. Ralph Winter, Judge Winter in the court below said that if people withheld medical care from a child because it was of the wrong race, was too black, that was not a medical judgment. And the argument here of the administration is that if you're withholding this medical care because you think that a person afflicted with these disabilities has a life not worth living, that is not a medical judgment. It's a moral judgment. It's a matter of drawing an inference about a person on the basis of a characteristic that could not possibly establish whether we're dealing with a good or bad person who deserved to be protected. Now, if that distinction that Ralph Winter and I were offering, if it makes sense to you, that there was a difference between a medical judgment and a moral judgment, that the moral judgment was drawn from attributes of a person that cannot possibly determine anything of moral significance. Nothing in the disability of this baby could bear on the question of whether that child had a life worth living. If all that makes sense, and I submit to you, the point here is simply grounded in what Thomas Reid would have called the mint of our human nature and the inescapable fact that these attributes, height, weight, color, deafness, spina bifida, truly are powerless to determine any judgment on the moral state of any person. And if that's true, the question naturally presents itself. If we shifted the locale and the hospital were not in Long Island, but in Tehran or Nairobi, would the judgment really be any different? Would it not be just as wrong in any of these places, distant in space or time, to judge that a person afflicted with spina bifida and Down syndrome has a life not worth living? Now, if we recognize that simple point, we would have recognized that this judgment of ours on the wrongness of withdrawing medical care on that basis, that this judgment of ours does not simply reflect some ethic that prevails in this tribe of Americans. The judgment is grounded in nature, in the laws of reason themselves, in truths also that could be grasped by any functional person. And there's nowhere in the world where they would not hold true. Without any sense of astonishment or any sense we're doing it, we would find ourselves backing again into the N-word that dare not speak its name, the natural law. But at the same time, when we consider how those problems, those principles bear on a problem like that of withholding medical treatment, then we can see that in striking contrast to the cliches we often hear, even from some of my old friends, there is nothing the least foggy about these principles of natural law. They may be precise and concrete, as they bear on cases like that of baby Doe in Long Island. There's nothing inscrutable about them. They do not suddenly become woolly or incomprehensible to any man if he's suddenly clothed with the robe of a judge. What Peter had some familiar problems getting hold of here is the fact that we're dealing with propositions that are true of necessity, forming the ground of the law. And they are moral propositions about right and wrong. They were true in all places because they were true of necessity, not because they were recognized in all places. You know, as Aquinas explained, it's a self-evident truth that the angles of a triangle will add up to 180 degrees, but it may not be evident to every self happening down the street. The wrong of killing the innocent in genocide is true in all places, even though it is still practiced in too many places. In other words, we don't test for moral truths by trying to survey whether they are accepted in all places. But on this matter of original understanding, I was in a conversation with our dear friend Nino Scalia, and I recalled to him Lyman Trumbull managing the Senate, the bill that would become the 14th Amendment. And he had to assure his colleagues up and down that nothing in that, the equal protection of the laws, was going to threaten those laws in Illinois as well as Virginia that barred marriage across racial lines. And he knew that if he couldn't offer that assurance, that bill had no chance of passing. And so I asked Scalia, will that mean that that the court should not have taken Loving versus Virginia in 1967 and struck down those laws in Virginia that barred miscegenation? He said he'd have to think on it. Well, I don't think there's any way they were going to call back, conservative court was going to call back that judgment. But yet, apart from the politics, it should be clear that the laws that bar marriage across racial lines do indeed pivot on the discrimination based on race. Trumbull and his generation could not make that connection, but it's no knock on Trumbull that he didn't see the fuller implications arising from his own principles, because it's the life of moral experience that we may discover implications of our own principles that have heretofore gone unnoticed. How else can we explain that novelty that the court brought into family law in 1984 in Palmore versus Sadati? A divorced woman lost custody of her children because she went on to marry a black man. In deciding on matters of custody in these cases, family law put the accent on the interests of the children, and in this case, the candid assessment was that a social stigma was thought to come for children if they were known to have a black father. But what this meant was that some people, simply on the basis of race, were losing custody of their children. The recognition finally broke through that this reigning custom in family law was quite at odds with the principles articulated now in the fundamental law of the Constitution. Now, it's a question for Peter. Would this strike Peter as an example of the vice of judges going beyond the text to reach conclusions that were never foretold in the case, quite at odds with the understanding of those people in Congress who drafted, framed, and voted for the 14th Amendment? But now we have the completion of the story, and perhaps the word to close down the current fable on originalism, with our friend Steve Calabrese. I knew Steve at Yale in the early 80s when he was helping to launch the Federalist Society, and he's been a prime defender of originalism. It marks a notable, I'd say, seismic shift when Peter discovers that the case for same-sex marriage is simply contained in the logic of the Equal Protection Clause, that right has been embedded in the logic of that clause, even though no one saw it at the time or even in our own day. And since the right is embodied in the very logic of the Equal Protection Clause, the discovery of that meaning is now quite consistent with originalism because it was part of the meaning of the Equal Protection Clause from the very beginning. As we've seen, this is exactly the kind of claim that could be made for the wrong of barring marriage across racial lines, that the wrong is contained in the logic of the Equal Protection Clause, even though nobody saw it at the time, okay? So the difference between that understanding and the one put forth by Steve Calabrese can turn solely on the substance of the argument, that there could indeed be no justification for drawing adverse moral inferences about people on the basis of race, but it takes a severe filtering of moral reasoning to claim that there's no substantive moral argument to be made for the laws that have long confined marriage to a man and a woman. But the completion here comes in showing where Steve Calabrese has brought us. We have now one of the founders of the Federalist Society, a high priest of originalism, and a friend of mine, who thinks that originalism, rightly understood, can encompass moral understandings never contained in the text of the Constitution, never understood by the people who framed and ratified the text, and that could all be absorbed now in the doctrine of originalism as though it had been there all the time. And except for what I think is a serious mistake in the reasoning on marriage, well, the rest of this would flow without strain if that judgment on marriage were correct. But the rest, I say, is quite defensible. So I would say to Steve, welcome home. You've made the return to natural law, and it's been here waiting for you all along, because in truth, we never left it. Peter warns that if we take the natural law seriously, we'll be drawn in this way outside the text, but that is inescapable. I have another case I can show where Scalia was persistently drawn outside the text. Yet we see judges moving out the text, yes, to invent new rights in accord with the liberal agenda. But if we're convinced those rights are spurious, the apt response surely is to test the reasons and show why they are spurious. Just to register our sense that these constructions are spurious is already to indicate that we have access to standards of judgment that allow us to tell the difference between constructions that are plausible and implausible, spurious or convincing. Okay? To ask whether judges can actually get through their day without touching those axioms of reasoning, the very ground of the natural law, is rather like asking, can I order the coffee without using syntax? The judges find themselves persistently backing into the natural law, for in point of fact, they've never left it. To take that line from Moliere, they discover that they've been speaking prose all their lives. They've been relying on the natural law, even as they remain utterly unaware that they're doing it. And to ask just when judges may rightly invoke the natural law is to miss exactly the same point. The judges are using it at every turn, for it has never left them. And with that sense of the principles unseen, I take me back to my concluding story. I was giving a talk on natural law at the law school at Fordham for my book, Natural Rights and the Right to Choose. And after dinner, the dean had a dinner for me, and the dean remarked that those lawyers and judges in the founding period never said much about natural law. To which my friend Dan Robinson remarked, yeah, they never said anything about the alphabet either. But it was woven through everything they did. This is the way they did law. And finally it struck me that we may be dealing here with what the philosophers like Gilbert Ryle called a category mistake of mixing things like, she arrived in a sedan chair and in a veil of tears. To adapt that old example, Gilbert Ryle, let's say someone came to visit me at Amherst. I showed him the Earth Sciences building, the Social Center, the beautiful building where I had taught. And I take him home for a drink. And he turns to me and says, all right, but I thought you were going to show me the college. I thought that's what I was doing. So the equivalent is this. We have friends saying, all you've shown us is a generation, a core of literate lawyers and judges who had a rare capacity to trace their judgments back to those axioms that were there and those rights that were there before the Constitution and would be there even if there were no Constitution. When are you going to show us how they did natural law? We say, you already have. Okay.
Thank you, Professor Arkes. Thank you both for that enlightening exchange. I'm going to offer a few comments and pose a few questions that I hope will help clarify the terms of the debate before we go to the audience Q&A. So the question that we are discussing today is whether natural law and originalism are compatible or at odds. And in assessing that question, I want to suggest that it is essential to distinguish three different questions. And here I follow Professor Russell Hittinger, who very helpfully disentangled these three questions in chapter 3 of his book, The First Grace. And those three questions are, first, does natural law exist? Second, assuming natural law exists, how is or should it be implemented by government in a specific polity? And third, assuming natural law exists and the positive law of a specific polity assigns the task of implementing the natural law exclusively to the legislature, does there nonetheless remain a role for the courts in implementing the natural law? And those three questions are distinct and descend from a higher level of generality to a more granular level, and conflating them often causes confusion in debates about natural law and originalism, in my view at least. And so it's easy to talk past one another when one person in the debate is addressing one of these three questions while another is addressing a different set of questions. So I hope that in what I have to say now and the questions I will pose, that we can help clarify exactly where our two interlocutors are disagreeing. So the first and most basic question is, does natural law exist? That is, to oversimplify and bracket a whole bunch of debates about what natural law is, we could define natural law as principles of practical reason that are discernible to human beings and, by virtue of their being true, ought to guide human action. Now, this set of questions would include the classic debate between natural lawyers and positivists about whether a system of positive law can properly be described as law, apart from any consideration of its moral content. Sometimes people are originalists because they doubt the existence of natural law and believe that it'd be impossible for judges to appeal to objectively correct principles of practical reason. I do not believe that our two interlocutors are debating this first set of questions. Professor Arkes certainly believes that natural law exists, and Mr. Wallison seems to be willing to assume for the sake of the argument that the natural law exists without taking a position one way or the other. I understand Mr. Wallison's concern about courts inventing new rights not listed in the Constitution to be more of a concern about how the idea of natural law might be abused by judges, not as a denial that natural law exists, though Professor Arkes' remarks suggest that he does seem to think that Mr. Wallison's denying the notion of objective truths of practical reason. So my first question would be directed to Mr. Wallison and asked whether he agrees with my assessment that his argument is not based on a denial of the existence of natural law. I hope you'll just hold on in responding to that until I finish with the other questions. So the second question is, assuming the natural law exists, as I believe both of our interlocutors are willing to at least assume for purposes of this debate, how is the natural law to be implemented or made effective within a particular polity? As Professor Hittinger notes, this question could be taken in either a normative or a descriptive direction. We could ask how the natural law should be implemented in our polity through the positive law, or we could ask how the natural law is in fact implemented in our polity through the positive law. Of course, if we make this a descriptive claim, we need a method of interpreting the Constitution to figure out what it requires, and that would then require a normative theory to support whatever principle of interpretation we use. So it's possible that these normative and descriptive questions collapse into each other, that you have to be making both types of arguments. But if we take this as just a descriptive question, the question would be, does the United States Constitution assign the task of implementing the natural law to legislators, to judges, or to both? And here I think our two interlocutors are indeed disagreeing with each other, though it's less clear to me whether their disagreement is descriptive or normative. If we assume that there is a natural law, I very much doubt that either of our two interlocutors would deny that legislators should and do have a role in implementing the natural law under our system. So the real disagreement, whether descriptive or normative, is about the judicial role. There are times when Professor Arkes seems to suggest that the Constitution allows, even invites judges to implement the natural law through judicial decisions, as when he argues that the founding era understanding of the judicial role included appeals to the natural law, and when he points to portions of the Constitution's text, such as Article 3, Section 2's description of the judicial power extending to equitable cases. And this would be more of a descriptive claim that assumes an originalist method and seems to say that even under an originalist method, natural law is permitted as a resort in interpreting the Constitution. But at other times, Professor Arkes seems to suggest that any defensible system of positive law must allow judges to implement the natural law, which is more of a normative claim. By the same token, there are times when Mr. Wallison seems to argue that the Constitution, as originally understood, does not assign to judges the task of implementing the natural law, which is more of a descriptive claim, such as when he notes that originalists would argue that the amendment process is the proper avenue for implementing moral principles not stated in the text of the Constitution. But at other times, he says that allowing judges to implement the natural law would be illegitimate because it would allow judges to abuse their authority and impose their private views on our society, which is more of a normative claim. So my second set of questions, directed to both interlocutors, is whether they are making a descriptive argument about whether the Constitution allows judges to implement the natural law, or whether they are instead making a normative argument about whether the Constitution should allow judges to implement the natural law, or are they making both types of arguments? And finally, assuming for the sake of the argument that the natural law exists and that the Constitution allocates authority to implement the natural law exclusively to the legislature rather than to the judiciary, and I take it that Professor Arkes would probably dispute that assumption, but if we just assume that, there remains the question of whether the judiciary will necessarily, in order to discharge its duties as defined by the positive law itself, be required to appeal to the natural law in at least some subset of cases because the positive law simply cannot be properly understood apart from the natural law. Here again, I think our interlocutors are disagreeing, though perhaps not completely. Professor Arkes seems to argue that even if the Constitution assigned the task of implementing the natural law to the legislature, it is simply impossible to adjudicate cases under the positive law without resorting to the natural law in at least some instances, as when he invokes the idea that the natural law consists of axioms necessary for sound reasoning. I take Mr. Wallison to be arguing that it might be necessary for judges to resort to the natural law insofar as the positive law explicitly refers to natural law concepts or to concepts that are only coherent when understood within a historical context that includes natural law assumptions. At least that's what I thought he was arguing when he cited Justice Thomas and Justice Gorsuch's disagreement in Sessions versus DiMaia as an example of legitimate originalist invocations of principles not explicitly stated in the Constitution. So the third question to both interlocutors is, to what extent do they believe that judges must necessarily resort to the natural law in interpreting the positive law, even assuming that the Constitution, as properly interpreted, assigns the task of implementing the natural law to the legislature? So, to recap, question one for Mr. Wallison: are you arguing that the natural law doesn't exist? Question two for both interlocutors: assuming that the natural law exists, are you making a descriptive claim about whether the Constitution assigns the task of implementing the natural law to judges? Or are you making a normative claim about whether the Constitution should assign that task to judges? Or are you making both types of claims? And the third set of questions to both interlocutors: assuming for the sake of the argument that the natural law exists and the Constitution assigns to the legislature alone the responsibility for implementing the natural law, to what extent do you believe that judges must necessarily resort to the natural law in interpreting the positive law? So I hope those questions will provide some clarity to the discussion. And I think I'm going to start with Mr. Wallison, since he started our initial round of discussion.
Well, I don't think I made all the notes that I should have made as you were talking, but I guess from my point of view, we're talking about two really different things. Does the natural law exist? I have no argument that it doesn't exist if it is what the kinds of principles that Hadley articulated, and they all seem very obvious. And that's one of the reasons why he's arguing for these principles as being part of something called the natural law. But from my perspective, what we are really talking about when we're trying to compare originalism with natural law is, well, call it oil and water or glass and cement. They're different in concept, because originalism, as I see it, I cannot say that I am an originalist because I haven't done the study of it, but I believe that as a conservative, that's probably what conservatives prefer. And the reason is, I think, that it requires judges to be much more careful about how they resolve cases, and that what originalists are attempting to do now, and this is why I talked a lot about what two originalists were doing, Gorsuch and I've forgotten all I guess it was Thomas and Gorsuch. What they were trying to do in their concept was to say, we are focusing on and tying ourselves to things that can be demonstrated as part of what was the common law in the mother country. And the reason we are doing this is unstated, but the reason we are doing this is that we don't want people who believe that the Constitution has no purpose other than to be interpreted in certain ways to permit certain new liberties or restraints that the initial drafters of the Constitution had in mind. This is a very defensive proposition. They are trying to be sure that they can control in some way how the Constitution is interpreted by rooting it in things that can be ascertained in looking at the history of what how the Constitution was drafted and what the framers thought they were doing. That doesn't exclude natural law, because as Hadley has made very clear, some things are perfectly obvious when you look at various constitutional principles. I mean, they have to be based on some idea of common sense. But when you go beyond that, when you go to such a thing as, for example, whether a marriage can be between two same-sex people, that's not obvious. And it certainly wasn't obvious to the three dissenters on the court, which included Scalia. I mean, it might look obvious to us now, after we have experienced 10 or 15 years of people we know being in those kinds of relationships, but it isn't obvious. And the point, I guess, that originalists are trying to make is we don't want a court made up of people who believe that they can develop new rights or even new restraints from looking at something called the natural law that nobody else is necessarily carrying on in his head. Now, I don't know whether this is an answer to all your three questions, but I think it's the reason why it is so difficult, I think, or will be so difficult for originalists to take on, support, believe in the positions that Hadley is expounding. And he's got friends, or some friends that are still alive, but once at least one in a former justice of the Supreme Court, Antonin Scalia, who was one of the founders of originalism. And he never got an answer, at least he isn't telling us what answer he got when he posed the questions that he posed to Scalia. I guess the response was, well, let me think about that.
Right.
And that's a good answer. That's a good answer. But I think after he thought about it, I think, and based upon his reaction to Obergefell and the idea that the courts can just decide that same-sex marriage is permissible, he would probably not have agreed with the proposition that Hadley had put before him.
So if I may quickly just follow up on that, Mr. Wallison, I want to make sure I understand. It seemed to me from what you said that first you're not taking a position one way or the other on whether natural law exists. You're not necessarily disputing it or endorsing it. You're just kind of leaving that to the side.
Yes,
You're saying that originalists would take the normative view. They would make a normative argument that judges ought not be implementing the natural law, and that originalism is a means of preventing them from doing that. And that originalism does, it can prevent them from doing that. It is not impossible to adjudicate cases without resorting to the natural law. I took that to be the substance of your response.
Yes, that's right. Although there might be principles of the natural law that are logically unavoidable when you're handling particular cases. That's all.
Got it. Professor Arkes.
I didn't know where to cut into this. You have so many things. And I just did a talk that would probably answer almost all those questions. I don't believe in the natural law any more than I believe that it's wrong to hold persons accountable for acts they were powerless to effect, or that two contradictory propositions both cannot be true. The question begins by rejecting the possibility that there are indeed what the founders recognized as necessary truths underlying their position. If that's the case, the natural law is involved at every level of the government. The legislature of Texas passes a law to offer the protections of the law over unborn children. The conservatives never talk about that. They simply want to know, is abortion in the Constitution? The question was whether those laws protecting the unborn child were justified, were there reasons and evidence that would support. The lawyers who were doing that work were putting together an elegant brief to show the case. What they were doing, giving us the jurisprudence of natural law, even if they weren't invoking the N-word. James, to pick up your line about James Wilson said that, invoke the Declaration of Independence. The very purpose of having these governments was to protect natural rights. It was the function of all parts of the government, of the executive and the Congress, no less than the legislature. Well, what did Madison say in Federalist 10? These acts of legislation are nothing other than judicious acts. Now, the judges who work with the scheme I've just described, they find their business in articulating jural principles. They would help to explain to us, for example, why the person who gets in off the plane flying in from London, why we don't have to look at his passport to come to the judgment that he has a claim to the protection of law that does not depend on his citizenship. But the judge I have in mind would not then tell you that that same person can go to the City College of New York, regardless of residence requirements, enroll for the subsidized rate of tuition. They recognize in particular places, like the right to use the squash courts at Amherst College. My kind of judge would know. Well, let's think Clarence Thomas raised the question. Why is it a compelling interest for the people of Michigan to support an elite law school where 70% of the students will leave the state, rather than using the same amount of money to support medical care for the aged? That's a policy judgment. The judges I'm describing don't do that sort of thing because they know that kind of decision will depend on the generosity of the community, what the community thinks is important to support. The judges realize this is not part of the kit. Nothing in the kit of judges giving them the standards to do this. Peter raised the question of FISA. No, it doesn't clear that any of these things tell us what kind of powers you give to the FISA court, just I wouldn't give certain powers to judges. And at the same time, I say we don't count on the judges to enforce these things. The city of New York put in measures to inspect bags of people entering the subway when there's a danger. They had signs of attempt to bombing. When the question was raised, are there any constitutional issues? People would say, yeah, it's a matter of searching bags, search and seizure. But the deeper constitutional issue is the right of the ordinary people to be protected against lawless assaults on their lives. It was the city authorities in New York who are exercising that function and protecting natural rights, not the role of the judges. So, as Hamilton say, the Constitution itself is a Bill of Rights. It puts in place a government with a competence to protect those rights. You raised an interesting question about originalism, that we may avoid these serious questions, some of these serious questions, by simply being originalist. It's probably like a problem that occurred with Amy Comey Barrett a couple of years ago, when we were both arguing at the Alliance Defending Freedom. And she said she was committed to the positive law, and would take her guidance from the positive law of the Constitution. And a student got up and said, but why does that positive law have about it a claim to your adherence, a claim to your respect? Why is it different from the positive law of Stalin's Russia? The question compels us to raise that question. Lincoln gave the most interesting account in the first inaugural address of why the rule of a majority under constitutional restraints is the only a majority that understands it's not free to discuss everything. It has moral and constitutional restraints. Why that kind of a majority is the only operational form of government by the consent of the governed. But all that presupposed that the principle was in place, that the only rightful form of government is one in which human beings would not be ruled in the way humans rule dogs and horses, depends on the consent of the governed. The difficulty for some of our friends is that they want to consider the Declaration and those principles outside the Constitution. It's nothing, of course, they had to be in place before you were oriented in enacting a Constitution. But if you see the rule of a majority detached from an underlying principle, then it becomes, as Holmes said, why do you have the rule of majority? Because the majority may overbear the minority, which is to say, the rule of the strong, or might makes right. Peter remarked that his paper, his concern, I've heard widely expressed, that when judges leave the text and are appealing to moral arguments, they're in a world of subjectivity. But that position depends on the rejection of any principles out there, any laws of reason or necessary truths that provide the standards for assessing argument and giving us the discipline of reasoning over matters of right and wrong. But if you do that, what you're saying is you doubt there really are moral truths out there that form the ground of the natural law. Okay.
If I may, Professor.
That becomes decisive.
I think we should probably try to get to, thank you for that. And I really do appreciate the response to the questions that I posed. And I think we should now turn, in the remaining time we have, which is only about 9 minutes, to some questions that we have fielded from the audience. So the first question comes from Robert Berger, and I've reformulated it a little bit in the interest of time. But Robert is asking whether either of your views, Mr. Wallison or Professor Arkes, on this question of the compatibility of originalism and natural law depends at all on what version of natural law we're talking about. Are we talking about the natural law of John Finnis versus some other natural law theorists like Russell Hittinger? Or are we talking, and same thing for originalism, there are all sorts of different varieties of originalism, original public meaning, original intent. And so Robert's question is, does your view at all depend on what type of originalism or natural law is at issue? So we'll start with Professor Arkes.
Well, yeah, what the force of my argument was that I was detaching myself from various theories. There are things I find in the new natural law of John Finnis that I find very plausible, and I think I'd incorporate them in my own understanding. But I wasn't taking this occasion to give a critique of everything else that's offering itself as natural law. I was offering what I just thought to be the most defensible, coherent ground of the natural law, and a form that is understandable to ordinary people, and the form understood by the American founders. And the point is that when the founders, like Marshall and Hamilton and Wilson, were tracing their judgments back to those anchoring moral principles, do we think they were not doing law? Where did this stuff, when we say things like that, it's morality rather than law, we seem to be the children of Holmes. Holmes saying in The Path of the Law, the object now is to purge all words of moral significance from the law altogether. And by my dear friend Anthony Scalia, by the time you get to the case on marriage, Scalia could say, in the voice of modern conservative jurisprudence, on what form of marriage is desirable, I have nothing to say. I'll simply ask whether the term is marriage is mentioned in the Constitution. But it wasn't mentioned in the Constitution when the courts did Loving versus Virginia in 1967. But this is part of we've got here a conservative jurisprudence that prides itself on avoiding those questions. So look what we have right now as a result of Neil Gorsuch's decision in the Mozart case. We have a person who claims to be an originalist, who tells us originalism is compatible with a judgment that says any wrong done to a person who's transgendered overrides the significance of those objective truths grounded in nature that separate men from women. Steve Calabrese tells us that originalism is personally compatible now with the recognition of same-sex marriage, and other people affecting to be originalists are supporters of the right to abortion. By the time you've added this up, I say, well, what's the implication? That it's a metaphysic without consequence, you might say, that originalism professes to have nothing to say on the gravest questions before us in our law. And the uneasy thing is that some people take that as a point of pride. Look what we've done. Holmes wanted a law purged of moral significance and giving us a pure science of law.
Mr. Wallison, any response on that before we move on?
Are you asking me?
Yes. Do you have any response
Yes.
to the question before we move on? Okay.
Yeah. My problem with the idea of natural law is that it is so evanescent, so difficult to pin down. And I think part of the question that is coming.
But it was pinning it down.
Well, yeah, you're
My
giving
talk.
examples of it. You're giving examples of it. But I gave an example, which is every man for himself, said the elephant as he danced among the chickens. Now, that's the underlying idea there, is that for certain people should be able to, or do have the right or the power to harm other people, not in physical ways, but in other ways. And should we base a society on a principle that shouldn't be permitted? And if that's where we go with that as a principle of natural law, we are going to have a completely different society from the liberty-based society that the Constitution embodies. So I really have a lot of difficulty with, I can't deny that many of the propositions you talked about are correct, but there are many others that could be added that would change in major respects how our government and our system works.
But Peter, you read me about the argument against the Bill of Rights, and what the classic liberal position would be, you have a presumptive claim to all dimensions of freedom, to braid hair, do sculpture. You have all dimensions of your freedom. And the burden falls to the government to offer a justification for restricting your freedom. It's a wider view of freedom, but it's going to simply depend on what kinds of reasons we can give. I see a youngster with a bike going into the subways in DC. I say, you can do this? And he says, yes, but not during rush hour. He knows that it's reasonable to restrict his liberty to move under. These are decisions that ordinary people make every day. There is nothing obscure about them. So I said, I think what I've given you is some clear example. Now, if somebody said, I want to skip and dance, whatever you said, then we say, well, is it a right you're claiming to do it? And there you claim it also, it would be wrong for someone to interfere with you? Ah, okay. Now we're in the business of just looking more closely at the standards underlying assessment of right and wrong. And with marriage also, yes,
Professor,
everything else.
I do want to get one last question, if I may, and this specifically aimed at or directed to Mr. Wallison. We have about a minute and a half left, and we have a question from Dennis Teddy, and he says, you speak of the expression common good as an area or subjective idea that has no place in interpreting the Constitution of the framers. In Federalist 57, Hamilton, or possibly Madison, writes, the aim of every political constitution is or ought to be first to obtain for rulers men who possess most wisdom to discern and most virtue to pursue the common good of the society. Doesn't this mean that those who govern the U.S. under the Constitution must determine what the common good is? And if you wouldn't mind answering pretty briefly, because we do need to wrap up.
Is that question for me?
Yes, that's right.
That's one of the wonderful things about stating the purpose of a society being the common good is that it has no understandable definition. What's good for some people is not necessarily good for other people. And if you wanted to take it to the libertarian point of view, if you are going to insist that we level society so that there are no elephants dancing among the chickens, you have a completely different concept of common good than one in which the elephants are allowed to continue to do the things that they do in increasing our economy and growth and so forth for the benefit of the chickens. I just think that there's so little consideration of what it would mean if we just looked at moral propositions that seem good to us at any given time and reflected those in how our system works. If we are going to do that, we ought to do it with legislation, or we ought to do it with amending the Constitution, but not importing new moral ideas that are going to change in major ways the way our economy works.
That'll have to be the last word on this debate, and thank you both. Thanks to AEI and the James Wilson Institute for this enlightening discussion, and thank you all for joining us.
We're in heated agreement. We're in heated agreement. Lovely. Thank you, Peter. Thanks so much. Okay.
And Joel, terrific work. Thank you very much. Your summaries were excellent.